Welcome, everybody. My name is Marty Mascari. I am a contractor under the North Central Texas Area Agency on Aging and the North Central Texas Aging and Disability Resource Center, both of which are under the umbrella of the North Central Texas Council of Governments in the greater Dallas-Fort Worth, Texas area. We're thrilled to have all of you on, but we're really thrilled to have our partners at the North Texas Fair Housing Center, namely Frances Espinoza, who's the executive director, to share her knowledge with us on everything you need to know about tenants' rights in Texas. But before we get started, we're going to cover a little bit about CEUs. So those of you that are looking for certificates. So if you're joining us today and you're looking to get a certificate, either a CEU or just a certificate of attendance, we are offering today and set up to provide CEUs for licensed social workers and licensed professional counselors in the state of Texas. Anybody else that has a different license in Texas or has a license outside of Texas, you're more than welcome to go through the process and get a certificate. But please know that there's no guarantee that they will take it. That's just totally up to them. We are just set up for these two licenses in Texas. Also, we'll be offering certificates of attendance to those. The guidelines are the same for both the CEU certificate and the certificate of attendance. Today, joining us today is worth 1.5 hours of CEU credits. You must complete the entire webinar live and the Q&A, which should consist of an hour and a half, which is what adds up to your 1.5 hours. So please know if you intend for a fair amount short of that, you will not be eligible for CEUs, but you should be on for pretty close to 10 hour and a half. You must also complete the Google evaluation survey form. Zoom should, as you close out from the webinar, ask you if you want to go and take a survey, and that is the Google survey. And please do that. We ask everyone to do that if you would. It helps us with feedback and information about for future webinars. But if you are looking for a certificate at all, you will have to. That's a requirement. And so if you don't get the pop-up as you're closing out of Zoom, don't worry, you'll also get the link to that survey in the follow-up email that I send out to you either this afternoon or tomorrow. And so you'll have until the 8th of February to complete that. And then give us about a month after that to get certificates out. They take a while, and we've got a lot on our plate. So if you could give us, and if you don't have them by the 8th of March, you're feel free to email me and check on it. But if you could give us that time, that would be great. Frances Espinoza, the executive director of North Texas Fair Housing Center. I'm turning it over to Frances, and she's going to be our presenter.
Thank you, Marty. So today we're going to talk about tenants' rights in Texas. But before I start, I want to let you know, and hopefully this isn't a big downer, but Texas does not have a lot of laws that protect tenants or protect renters in Texas. Texas is a very pro-property owner state. And so there aren't a lot of laws on the books. And, a lot of that has to do with who represents us in the state legislature. They're not as concerned with tenants' rights as probably all of us on this webinar are. And so, that becomes an issue of, if we want to get more laws on the books or change the laws, we need to vote for people who care about these same issues. And right now, it's not that, new tenants' rights aren't proposed. It's just a lot of times, or most times, those new proposals they don't even get out of committee to get a vote. they get quashed in the committee, and so they're not even brought up for a full vote. So that's something to think about as we go through this, because a lot of times if tenants want to assert their rights, they first need to look at their leases to see what it says about the particular issue they're having. And then secondly, they have to go to Justice of the Peace Court or Small Claims Court to enforce their rights on most issues. And so just kind of keep that in mind as we move through here. Um, so I'm going to start off by talking about leases. And a lease is a binding contract. And I think because it's a living situation, a lot of people don't necessarily see it that way. When you buy a car, for example, you sign a contract that you're going to make monthly payments of whatever amount. And that's pretty clear to folks, but in a living situation, because it's a lot more personal, I think, people don't always see it as it's really a contractual relationship between the landlord and a tenant. And it can be for any amount of time, but the most common, of course, is 12 months. And leases, like I said, are typically they cover a lot of the issues that are not covered under state law. And so tenants have to look back at their leases, and the different things that could be covered in your lease are what happens if you don't pay your rent, what is the date you have to pay your rent? What's the last day of the month you have to pay your rent before you incur late fees, and then language about evictions, and things like that. So a housing provider has the right to not renew a lease after the lease expires. And I think that's a really important thing to know, because, I get calls every day from folks who are upset that they were told their lease is not going to be renewed. And so just to know that tenants don't have an absolute right to have their lease renewed. There is one exception to that, and that's in public housing. In public housing, um, the leases have to be renewed unless the tenant has breached in some way, and that has to be documented. But for regular market rate housing, you don't have an absolute right to get your lease renewed. Um, and then the consequences for breaking a lease, you could have something negative put on your credit report. If you leave and the housing provider claims that you didn't pay your rent or didn't, they could even say you leave in month 8 of a 12-month lease, they could try to put 4 months of unpaid rent on your credit report. Or they could send a collections agency to try to pursue you to try to get that rent paid. Okay. So security deposits are actually one of the issues that there is a law in Texas regarding security deposits. So the security deposit should be listed clearly in your lease, and most housing providers will use the Texas, it's like the TAA, Texas Apartment Association lease. And there's a section about security deposit, and they just write in the amount of the deposit. So this is what the law in Texas is that the housing provider has 30 days from the date you move out to either return the deposit, return an itemization of what they used it for, or a combination of the two. But you must leave a forwarding address for that 30-day clock to start ticking down. And so if you don't get either of those things after 30 days, then your recourse is to file a claim in Justice of the Peace Court, which is really what most other states call small claims court. But you can file in Justice of the Peace Court to get your entire security deposit back. And in fact, if they broke the law and didn't provide you with either the itemization or the deposit back after 30 days, you could actually ask for 3 times your deposit back. And that's written in the law, and that's a punitive measure for, housing providers that don't, that disregard the law. Okay. Late fees is also another issue that was recently clarified in Texas law just in 2019 because landlords were charging any amount for late fees, and sometimes they do a daily amount that never ended. And so the law in 2019 came out, which provides some clarity for late fees. So that should be outlined in your lease. And don't assume you have a grace period unless it actually says that in your lease. So if your lease says the rent is due on the first and it doesn't have any other information in the lease, then I would pay my rent on the first and assume that it will be late after that. Sometimes in leases, it'll say you have from the first to the third to pay your rent. And after the third day, if you don't pay your rent on the fourth day, they could give you a notice to vacate. So section 92.019 of the Texas Property Code is the new law, or relatively new, that clarifies what amount late fees can be. So if you live in a building that's 4 units or less, the entire late fee for a month cannot exceed 12%. So even if the housing provider gives you a daily late fee, once they get to that amount that equals 12% of your rent, then they have to stop giving you the late fee. They can start up again the next month if you don't pay your rent on time. But for that month, they have to stop once they reach that 12%. And then for larger buildings that are more than 4 units, the late fee cannot exceed 10% of your rent. And again, if they do a daily rate, which some of them do, once that daily rate equates to 10% of the rent, they have to stop giving you a late fee. Okay, we get a lot of calls at North Texas Fair Housing Center about entry into the unit. And so housing providers can enter your unit for repairs or maintenance. A lot of leases will state that the housing provider can enter even when you're not home. So you don't have the absolute right to be there when they go in. So, you can ask them to give you notice of when they're going to go in, but say it doesn't coincide with your schedule of availability, and you're not able to be there, they don't have to change that date that they're going to enter your unit for whatever the reason is they're entering. Um, so, be aware of that. And, a lot of leases will state that they don't have to give you notice to enter. And I think that's, something that a lot of tenants believe is true, that they are supposed to get notice and most times housing providers will give you notice, but you don't have an absolute right to get notified if they're going to go in to do any kind of repairs or maintenance. Now, they shouldn't just be going into your unit for no reason. So there has to be a reason behind it. If they're going to, and so it has to be a maintenance or repair reason, or for example, if you live in public housing, it might be for some sort of inspection that they do, which, for public housing, a lot of times they'll go in on an annual basis and do an overall inspection of your unit. And again, you don't have an absolute right to be there, but you can let your housing provider know that you'd prefer to be there, um, and see if you can get things scheduled so that it works with your availability. Okay. Let's do a quick quiz and you can type your answers into the chat. So are these statements true or false? Number one, I always pay my rent on time and am an overall good tenant, so I will automatically be offered a lease renewal. True or false? Oops. Are people answering? I can't see. Yes, that's false. Because oops. Yes, that's false because, like I said before, you're not automatically guaranteed a lease renewal. Number two, it's illegal for my landlord to give me a rent increase of 20%. True or false? Okay, so we're getting both true and false. And, this is a bit of a trick question because I didn't review it in any of the slides before, but I put it in here because we're getting a lot ever since, I guess technically the big the big wave of COVID ended, even though we keep going through these mini waves. But um, we're getting a lot of calls since COVID ended about rent increases because it seems like during COVID, housing providers weren't really giving increases, or if they were really minimal. And it seems like now they're trying to catch up. And so we're getting calls from people who are getting, $150 rent increases, all the way up to like $350 a month additional if they renew their lease. And so, there is no law in Texas that puts a limit on what a rent increase can be. And so be aware of that there's nothing illegal about a 20% rent increase. They could increase your rent $500 with your new lease upon lease renewal. And that's not illegal. There's no law in Texas that provides any information about rent increases. So housing providers can increase your rent whatever percent they want to. Um, you know, Sometimes they base it on what the current kind of market is for their area, for the area that the apartment's in, but they don't even really need to do that because they can give you a rent increase of any amount. Okay, number 3, it's been 2 months since I moved out of my apartment and the landlord has not returned my security deposit. That's a violation of Texas law. True or false? Yes, true. That is true. That's a violation of Texas law if they haven't returned your deposit or an itemization of what they used it on, and it's been 2 months already. So, like I said, the recourse for that would be for the tenant to take the landlord or housing provider to small claims court or justice of the peace court. And you need to do that in the court that services that area. So whatever courthouse is closest to where the apartment is, that's where you would file your claim. And remember, you can ask for 3 times your security deposit if they violated the law. Oh, and also, if you're going to bring a claim for the deposit in Justice of the Peace Court, make sure you do it within a year of moving out to be safe. Typically, for a lot of claims, the statute of limitations is 1 year. It might be longer for security deposit, but I'm not sure about that. But I do know you have at least 1 year. So make sure that you do that within, a year from the time you move out. Okay, let's talk about repairs. So there is, the law in Texas is um, not really super clear. It doesn't provide a lot of clarity about, it doesn't provide a lot of clarity about, for example, what type, habitability issues. A lot of other states have laws about habitability, and the law will list like specific things that make rental habitable. Texas law doesn't do that. So Texas law, it requires landlords to make an effort to repair problems that they have been notified about that affect the physical health or safety of an ordinary tenant. So the key there are things that affect the physical health or safety. So if you have a leaky faucet, that's probably not going to be one of those repairs that is going to be, something you could take the housing provider to small claims court on if they don't make the repair timely. It has to be something bigger than that, something that affects the health or safety. So say you have mold growing all over a bathroom, that could be something that affects the physical health or safety. So it has to be something, typically it's a problem that's a lot more, kind of a lot more extreme. Okay. So the steps that a tenant needs to take to get those repairs made, is give a written notice, of the repairs. And I know that a lot of apartments now use the portals even for repair requests. So figure out a way that you can keep a copy of that for yourself to show that you did put it in writing. And I don't know if these portals will email you that they've received a repair notice and that's your proof. If not, you probably can just, once before you submit it, you can take a screenshot with your phone to show that, you put in the notice and the date of the notice. The other thing you need to make sure to do is continue to pay your rent. So typically there isn't any repair issue that gives you the right to stop paying rent. Um, the way I describe it to tenants is, the roof could be caving in on you and you still have to keep paying your rent. So keep that in mind. And then 3, give the landlord a reasonable time to make repairs, typically 5 to 7 days. And then call the city inspector to see if it's an issue that they would come out and inspect and cite the housing provider for. Um, Now, city inspectors, code compliance, could even be a health inspector if it's mold. There's only certain issues though that they'll give citations for. They won't, for example, you have a leaky pipe, unless it's causing a flood in your unit, they're probably not gonna, they might come out and look at it, but they're probably not gonna cite the landlord for it. It has to be something like, I don't know, maybe your electrical panel is like sparking or something crazy like that. Um, and then the last thing is to give a second written notice if their repair isn't made timely, which again, average 5 to 7 working days, then give a second written notice that needs to be, that you still have that repair issue. Okay, so the remedies for a tenant if a landlord fails to make the repair. So the first one, repair and deduct, we don't recommend that because one of the requirements of that for you to be able to deduct from your rent is that the landlord has to have been notified in writing by an inspector, whether that's a health inspector, a code compliance inspector, building inspector. And that notice has to say that the condition affects the health or safety of the tenant. And then that inspector, also gives a citation for that issue that it needs to be remedied. And that is a really difficult thing to get done because health inspectors may not even come out, even if it's something really awful like black mold. And then building inspectors, they won't make citations or reports unless the issue raises to a certain level, a certain threshold. And one of the requirements is not only that they go out and look at the issue, but that they notify the landlord in writing that this issue affects the health or safety of the tenant. And so that particular item, there's some other steps that you would need to go through to do the repair and deduct, but because this particular one is so difficult to meet, this is the one I want to highlight for you. And this is why we don't recommend that you repair and deduct. If you decide that you're going to pay to get the repair done yourself, um, ask the housing provider if you can do that. And if they agree to reimburse you, get that in writing. If they don't, and you still hire somebody to make the repair, then your recourse for that would be going to small claims court to get your money back from the housing provider, the money that you spent on the repair. So another remedy for a landlord failing to repair is to terminate your lease. Now, if you're going to try to use this remedy in your second notice, which, I talked about in the previous slide, you have to give a second notice that the repair needs to be made. You need to state in that second notice that if the repair isn't made within 7 days, that you're going to terminate your lease. But again, the issue that you're highlighting that needs to be repaired, it has to be an issue that affects your physical health or safety. Okay, and I know, I know that your living environment, it's, it's very personal. Like no one wants to live in a place that isn't well taken care of. Um, and everything that needs to be repaired is probably important to you. I know it is to me. If I have a leaky faucet, it's annoying. I'm wasting water, that sort of thing. But, the condition that you try to terminate your lease for has to be something like pretty egregious for you to be able to terminate your lease. So just keep that in mind. Um, the other remedy is that you can, continue living there, continue paying your rent, and you can file a claim in Justice of the Peace Court and ask a judge to either require the repair, or give you damages, which could be, for example, a prorated rent back to you. So, if you paid $1,000 a month rent and because of the repair, maybe, I don't know, the rental was only worth 800, you could ask for, 200 back per month that the repair wasn't made. Um, you could also ask for a rent reduction moving forward for a length of time that equates to the amount of time you had to put up with the issue that needed to be repaired. You could also ask the court to terminate the lease. And with a court order to terminate the lease, that's probably the safest way to terminate your lease for a repair issue is to go to court and get the judge to order that. And then once you have that order, you can move out and just, end your lease. Okay. So let's talk about terminating your lease before your lease is up. Um, So if you want to do that, um, you typically you shouldn't do that, but there's always a term in your lease that talks about what the termination fee will be. So typically that's, that could be 1 to 2 months rent. It will probably also outline a reletting fee that usually is a little smaller than what the termination fee is. And the reletting fee, it might be something like, I don't know, $150. And that's just a fee to make the unit ready for the next tenant. And if your landlord agrees to let you out without you paying those fees, you need to make sure you get that in writing. Because we have tenants sometimes who, they discover something 6 months after they've moved out of a place, something on their credit report. And when they moved out, they asked their housing provider, I'm going to move out. And the housing provider is like, fine, go ahead and move out. Um, but, that conversation didn't talk about, am I going to charge you a fee if you just leave right now? If you just leave, if you just move out. And so after the tenant moves out, the housing provider puts something on their credit report. Um, Something that, either it's the amount that the termination and reletting fee would be equal to, and they find that on their credit report. And in some cases, what's really awful is, say they had like 5 months left in their lease, they'll find on their credit report the equivalent of 5 months rent, which, technically is unfair because the housing provider should only charge the tenant for the amount of months that it takes for them to find another tenant. So they can still charge the termination fee and reletting fee, but to charge 5 months of rent, they're probably going to find a tenant before 5 months is up. And so, if that happens, all of those things would have to be disputed in the Justice of the Peace Court. So again, if the tenant wants to have any of that remedied or that taken off their credit report, unless they are willing to go to the housing provider and pay that amount so that they can get a letter for the credit reporting agencies that they can use to get that taken off their credit report, then they need to go to small claims court or Justice of the Peace Court and sue the housing provider to try to get that off their credit report. Okay. In Texas, though, there are two legal ways that you can break your lease. And, a lot of times tenants can do these on their own. But in many cases, need an advocate to help them inform the housing provider that they should be doing this, because, a lot of housing providers don't know that these are legal ways you can break your lease. One is if you are a tenant with a disability and, you need a reasonable accommodation to break your lease without any fees or penalties. And that could be somebody who, for example, lives on a second floor unit and there's no elevator, and they become disabled and they can't, live in that unit because they can't go downstairs anymore on their own. They could ask to break their lease so that they could find a apartment that or rental that's more accessible to them. So that could be a reasonable accommodation. In that case, the housing provider might offer the tenant a first floor unit. And so that would probably be more reasonable than the tenant completely breaking their lease and moving out. But if a tenant needs to terminate their lease, for example, because they can't live independently anymore, or can't live on their own anymore, then that's a reason to break their lease, and they shouldn't have to pay any fees or penalties for doing that. The second legal way to break your lease in Texas is due to domestic violence. So, an example could be a tenant who is renting a place, maybe is 7 months into their lease, and their former abuser finds out where they live and comes on property and now knows where they live. That could be a reason to break your lease without having to pay any fees or penalties, because you no longer feel safe because now this person knows where you live. And for the reasonable accommodation, we use the Fair Housing Act, which is the federal law, to support the request for the accommodation. For domestic violence, we can use the gender provision of the Fair Housing Act, or there's also Texas laws that talk about domestic violence and being able to break your lease if you don't feel safe and the abuser finds out where you live. In the Texas law, there are some requirements. You have to get a protective order, for example, if you want to use one of the laws in Texas. And so, sometimes using the Fair Housing Act might be better because a protective order and getting one of those could make the situation worse. And that would be our argument for not having to get the protective order, and for just using the Fair Housing Act to get the housing provider to terminate the lease without any fees or penalties. Okay. So let's talk about lockouts, because we do get a fair number of calls from people, and there is a law related to on lockouts in Texas. And it's an interesting law. Some of it kind of doesn't make a lot of sense, but there is a procedure. So, for example, a housing provider can't just lock you out. There's steps that they have to follow before they change the locks and rekey the locks. But the situations where they can lock a tenant out are if the rent is not completely paid, in an emergency situation. So say there's some sort of natural disaster and it's dangerous to get back into the unit. Then I guess if the building's still standing, they could change the locks so that tenants can't go in there and get their belongings out, because, it could create a situation where the tenant could get hurt. They could change the locks or lock you out to conduct a bona fide repair, although that is a reason they can lock you out, but I've never heard of that happening. It seems pretty extreme if it's just a repair. And then if the tenant has abandoned the premises, then the housing provider can change the locks. So one of the things that's important to know is that a housing provider can't change the locks based on failure to pay rent unless they've given the tenant a 3-day notice in writing. And the 3-day notice states the day they're going to change the locks. So the earliest day of lockout, it has to state the amount of rent that's owed, a location where the rent can be paid, And this is the last item is the thing that kind of doesn't make any sense to me. They have to give you the right to receive a key to a new lock at any hour to go back into your unit. So to me, that kind of defeats the whole, I mean, why lock somebody out if you have to give them tell them where they can get the new key? But one of the things housing providers do is they lock somebody out and they don't give them notice. They just, somebody comes home and they're can't get back into their apartment. So they don't give notice, which is a breach of the law. And then they don't tell the tenant where they can get the new key. And so, these are important things to know because just like I said, just randomly locking somebody out, even if it's for unpaid rent, the housing provider has to follow, they have to follow these rules. So if a landlord changes a lock without giving the tenant notice, um, the tenant can again make a complaint. You'll hear me saying this a lot during the presentation because Justice of the Peace Court is where tenants can get a remedy when when their rights are violated. They can sue for if it's unjustified, the lockout, they can sue for damages. And those damages could be it could be the filing fees um for the court. It could be if they had to, get a hotel if they couldn't enter their unit for one night, 2 nights, whatever it is. And damages can also be equal to 1 month's rent plus $1,000. And so all of those things can be put in a filing if you have been locked out without the housing provider following these steps. Okay, we've been getting a lot of calls lately about eviction and unfortunately, a lot of calls from people needing rental assistance, which, they're, as far as I know, and, maybe we could talk about this at the end, there aren't, um, there isn't funding available for rental assistance. There was a lot of funds available during COVID, but it seems like those have all dried up. So we've been getting a lot of calls related to eviction. There is law in Texas about eviction. It's Texas Property Code 24.005. So the first thing that needs to happen is the housing provider needs to give notice to vacate. So this is the first notice. It has to be given by the housing provider. And this is not a court document yet. This is just a letter or a notice form from the housing provider um, that the tenant has 3 days to move. Um, they need to move in 3 days because their rent isn't paid. That notice has to be delivered to somebody in the household who's 15 years or older, or it can be sent certified mail, or it can be placed on the inside of the door. So this is one of those reasons that landlord or housing provider can enter a unit without any notice, just to stick this eviction or this notice to vacate on the inside of the door. So if any of these things are not followed, then those can be raised at an eviction hearing as defenses. And technically, like say you didn't get a 3-day notice, for example, and the first thing you got was the eviction court documents, and you never got the notice to vacate. That is a breach of the law. And technically, if you raise that as a defense at your eviction hearing, the eviction should be dismissed. The eviction action should be dismissed. And I say should be because sometimes, the judges, they either don't follow the law, or if the housing provider tells them, no, I did give them a notice, they're lying, and the judge believes the housing provider more than the tenant, they might not care that, what you're saying, and they'll believe the landlord that you were given the notice to vacate, and they won't dismiss it. So, because Texas is a very pro property owner state, a lot of judges are the same way. A lot of judges are kind of biased towards the housing provider. And so a lot of times they don't even let the tenants talk in court. Especially if it's a eviction based on non-payment of rent or unpaid rent. They don't care about anything else that happened. If there's unpaid rent, they won't even listen to anything the tenant has to say. Okay, so then once the 3-day notice has expired, so say on the 4th day, um, the landlord can then file the eviction in court. So that gets filed in Justice of the Peace Court, which is the same court that tenants could take the landlord to if their rights are breached or their laws breached. So typically the court filing is going to be in the court that is closest to where the apartment is located. And there's a lot of things that the filing has to have in it. Address of the apartment, description for the grounds for eviction. If it was based on unpaid rent, it needs to have the total rent that's due. It needs to state if the landlord is seeking the attorney's fees, and all adults on the lease must have their name in the document. So if they didn't include any of these items, again, this is something that the tenant could raise in court. And if these weren't followed, if some of this information wasn't in there, they could raise that issue to get the case dismissed for not, for not following procedure. But again, that's not an absolute because, depends on if the judge is open to hearing what the tenant has to say. So when you get served an eviction, it'll look like a court document in that, it'll have an official stamp on it, for example. And it will also list a hearing date. So the date and time of the hearing. And the time from when you get served this notice to the actual court date, it varies and it really depends on how impacted the court is. So, typically it's between 10 and 21 days from the date you get served. But, really that it varies. It just varies a lot based on, and even court to court, it varies. Like it might take longer, for example, in Dallas, if there are more evictions than in, Louisville, for example. You could get a hearing date that's really quick in Louisville if the courts are not impacted. So, just keep that in mind. You can file an answer before the hearing if you dispute the eviction or the grounds for the eviction. You can file your answer before the hearing. And hopefully by filing that and putting it in writing, the judge will review it and consider it. And the court date, make sure that you appear, because if you don't, there'll be an automatic default judgment for the housing provider. And that hearing, is hopefully, if the judge, like I said, is open to it, it's your opportunity to tell your side of the story. Sometimes we go to different courts and just kind of sit and watch to see what happens and how, the judges proceed with these matters. And in early January, I was at the courthouse in Hurst, Texas. And, they brought everybody into the courtroom. So all the people who are being evicted we're all brought into the courtroom just to sit in kind of where the, I guess, audience sits. And one by one, the judge called their names and then and asked the attorneys who are representing the housing providers, how much they owed. And this particular judge wouldn't give the housing providers any attorney's fees or court costs. They just wanted to know what the rent was and the number of months the person owed. And they noted that, and then didn't only asked if the tenant had a defense, but there really is no defense to unpaid rent. So, you know, if there wasn't any circumstance, how can I put this? How can I explain this very well? Most times, none of the tenants on that particular day were allowed to give any kind of reason as to why they couldn't pay, because the judge didn't feel like there was an excuse for not paying rent. And so, it was a really quick kind of how many months do they owe? And then one by one, the judge called up the tenants and just put them on a payment plan for paying back what they owed the housing provider, or asked them to pay the whole amount that day. So it was really kind of interesting, but the tenants they didn't get to say much, if anything. So, okay. So I kind of talked about a lot of these things already, but some possible defenses are defective notice, which means, they didn't follow the rules or didn't. Defective notice could be they didn't give you the 3-day notice before they filed the eviction. Um, failure to comply with contractual or other notice requirements, or maybe it was improperly delivered, no notice was given. Also, if the tenant is on a housing choice voucher, if the housing provider didn't notify the housing authority that they were filing an eviction, that could be a reason that the court should dismiss the case. So again, failure to wait 3 days, like say the housing provider did give the 3-day notice, but then filed the eviction on day 2 instead of day 4. Any retaliation by the landlord for the tenant trying to enforce their rights. So if the tenant, and this is a little bit hard to prove, but if the tenant can show that the only reason they were given an eviction is because they continually requested repairs, for example. But in that situation, the tenant has to make sure that they're current on the rent. Because if there's any unpaid rent, the judge isn't going to listen to somebody tell their story about repairs. And then another possible defense is you paid your rent. Because once you pay your rent, once you pay your rent or catch up or whatever the case is, if the housing provider accepts your rental payment, then they should dismiss the eviction because there's no basis for it anymore. So but you got to make sure that they dismiss it. And if they don't, you still have to appear on the court date and tell the judge that you paid rent and it should have been dismissed. And then, of course, have any receipts or proof that you paid the rent with you when you go. So after the court makes a decision at the eviction, um, either for the landlord or the tenant, you have 5 days from the date of that judgment to file an appeal. Now, tenants who file the appeal, um, they have to usually they have to put at least 1 month's rent into the court. They have to deposit it with the court when they file the appeal. And when the appeal is filed, then the next thing that will happen is it'll go to the next highest court, which is the county court, and you'll get a new court date. And it kind of stays or wipes out the original eviction. So, if nothing would appear on your record, for example, until the appeal is decided. And if the appeal is not decided in your favor, then the eviction would stand. And so, you know, keep that in mind. And also by filing an appeal, you don't have to move during that time. So that's going to lengthen the amount of time before you have to move out. So if neither side follows the appeal, then on the 6th day after the judgment, the housing provider can go back to the court and get an order from the court to have the constable remove the tenant from the premises. Okay. So another quiz, and you could type your answers into the chat. Which of the following is not a valid reason for eviction? There may be more than one answer. So which ones of these do you think are not valid reasons for eviction? Okay, let's go over them really quickly. So A, the tenant stops paying rent because the manager ignores repair requests. So remember, you can't just stop paying your rent because the repairs aren't being made. You have to keep paying your rent. So if you stop paying your rent for that reason, that is a valid reason that you could be evicted. What about B? The tenant asks for a parking space closer to their unit. That's a correct answer. That is not a valid reason for eviction. That's a reasonable accommodation request for somebody who needs to have a parking space closer to the unit. Um, C, the tenant lost his job, so he rents a bedroom to a friend to help pay rent. So unfortunately, that is a valid reason for eviction, because probably that's an unauthorized occupant. So if the tenant is going to move somebody else into the unit, they need to get the permission of the housing provider first. And typically the housing provider is going to require that that person's name be on the lease. So, not somebody who can just come in and rent a room from the tenant. They have to be put on the lease as a tenant of the unit entirely. So, and what about D? The tenant constantly verbally harasses his neighbor. That is a valid reason for eviction. Um, in neighbor to neighbor disputes, it really is the housing provider's responsibility to deal with those disputes and to resolve them. Um, you know, we receive a lot of calls with tenant disputes, and it really isn't a fair housing issue, because fair housing is deals with how is the housing provider being how is the housing provider dealing with the tenant. So if the housing provider is harassing the tenant, that could fall under the Fair Housing Act if the harassment's based on a protected class. But neighbor to neighbor harassment, neither of those tenants are the housing provider. So that's just a civil dispute that these neighbors are having. And the housing provider is the one who's supposed to resolve that. Unfortunately, I can't tell you the number of times that we get calls about this where, the housing provider doesn't want to step in, doesn't want to, penalize either of the tenants, doesn't give them notices. It's almost like they're afraid of dealing with the issue. And they're actually the ones that should be dealing with the issue. So, that could be a really difficult one, but you could be evicted or asked to move if you're harassing your neighbor. Okay. So that's the presentation for today. Here's my contact info. The best way to reach me is on email, and that's down there on the bottom right corner. Do we have any questions, Marty, that we need to
Um,
cover?
there are some questions in both the Q&A. There's several.
Okay.
Okay, are the justice of the peace court also the place a tenant should for go for a complaint?
So, it really depends on what the basis of that complaint is. So, in the presentation I described, kind of different examples where the tenant would have to make complaints in justice of the peace court. And maybe the way to think about it is, um, has the particular thing that you want to make a complaint about caused you damage? And if the answer to that is yes, and you could put a dollar amount on that damage, then yes, that's where you would take your complaint, is to go to small claims court and file. I hope that answers the question.
Yeah, I think that does. The truth of the matter is, outside of that, if it's not a monetary issue, um, where can people take complaints? And you've talked a little bit about the health department or the code enforcement in the city you live in, but there's really not any other place that you can do that. Is there a place to just,
No, no. And if there's, and obviously if it's a discrimination issue, you can make a complaint with us or with HUD. Um, but there isn't any uh administrative agency or government agency that oversees um rental units, that oversees housing providers. And I think that's kind of an assumption people make, is that, if their tenants' rights are violated, they can make a complaint somewhere. But really, there isn't a agency or an administrative body that handles those kind of complaints. I know a lot of people, make complaints to the Better Business Bureau because, the housing provider is acting as a business, or if it's, a large apartment building, it's a business, and you could make a complaint. But I don't know if the Better Business Bureau does anything but receive the complaint, and I don't know if they publish it somewhere. I don't know what they do, but yeah, it just isn't anywhere. There isn't any administrative body that, oversees housing providers or uh landlords.
This gets back into the you know um, as Francis said in the beginning, before she got started, the bad news is Texas is a very landlord-friendly state or property owner-friendly state, meaning that most of the laws are written in their favor. But the only way that gets changed is if we all make noise about it. And so, please reach out to your state representatives and let them know what the issues are, um and even if people are running for those seats, find out who has who's interested in helping laws get passed that are more favorable for tenants. I think, Sandra, that answers your question too. There really isn't a place for people to complain, and the landlord doesn't have to give notice about coming in for maintenance issues or that type of thing. I think you covered that already in the presentation. So if your apartment
Yeah.
floods, go ahead. I'm sorry.
Oh, and there was something in there about the tenants feeling like they're being spied on.
Yeah,
And again, that really isn't, unless they feel like they're being treated that way because of a protected class. And unfortunately, um, age is not a protected class in housing in Texas. So, they would have to say they would have to be able to support a complaint that they're being spied on because of something else, maybe their race or their religion.
yeah. Um, so somebody asked if your apartment flooded during due to a water sprinkler break. Um, and all they did is put fans in the apartment to dry it out, and they haven't done anything else or even checked to see if there was mold on the carpet needs to be replaced. Should the city inspector be contacted?
Um, I don't think a city inspector, you can always call them. It doesn't hurt to try. It doesn't hurt to call them and see if they'll come out and inspect it. Um, in my experience, I don't think they will though, because if it's not an ongoing issue and if the initial the initial repair was made or the initial leak was fixed, they probably aren't going to come in to review the fact as to whether or not the apartment did a good enough dry out of the issue of the situation. But like I said, it doesn't hurt to try.
Yeah. What
Um,
have they done enough remediation to really solve, to take care of the problem?
yeah, so that would be an issue that, if the tenant has to do remediation, like, I don't know, buy a dehumidifier to try to dry out that carpet. Because putting fans on it really doesn't do anything. You really have to, you need a dehumidifier to suck out all that water and maybe even more than one. But if the tenant has to do that, then, that would be something they would then go to small claims court to get reimbursed for if they had to be out of pocket to make any additional, to remedy it in a way that the landlord didn't, and they can show what it cost them to do that, then they can go to small claims court.
I'll go back to the thing you said about the I'm sorry, I've got something else popped up for me. I'm sorry. Um, I lost my train of thought. Sorry. I'll go ahead and
Oh,
forget.
no, that's okay.
I'm gonna leave it there. Something popped up here, and it's something I need to address. Sorry. Um, regarding repairs in a non-working AC unit or heating unit considered affecting physical health and safety?
So I think the answer to that is it varies. And I think that has a lot to do with the weather in Texas. So I think the answer is yes. If we're having one of those like heat waves, or actually, I don't know if it's a wave. It seems like the whole summer's hot. But check your local city or call your city that you're in and ask them if they have, because sometimes cities have ordinances and it's just for that city that states if the temperature outside is over a certain amount degree, then it's a violation of that ordinance to not have a working air conditioning unit. And I want to say the outside temperature is like 85, that where that threshold gets met. But because it's a city ordinance, and if the landlord is violating that ordinance, then a city inspector will come out to look at that and to do a citation. But if it's 75 degrees and you're just somebody who runs hot and the ordinance says 85 degrees, you're not going to really be able to do anything but a regular repair request for that AC.
I'm just going to go back to reiterate the idea of making the call anyway to the city and just
Mhm.
seeing. And I say that because it has so much to do with the person that you're talking with. What kind of demand is on them on their job? How busy are they at the time? But there's a possibility you might call there and somebody and get somebody who's had that problem before and pretty sensitive about it and decides they're going to do something about it for you. And so you just don't ever know. So you always want to make that call and try.
Yeah, because like I said, it never hurts, right?
Yeah,
The worst that
yeah,
can happen is they say, no, we're not going to go look at that. So,
yeah, yeah. And a lot of times it has to do with just the person, deciding to do it or not. Really, I
yep,
mean, and
yep.
so someone asked here, does the domestic violence umbrella cover stalking and dating violence, etc.?
Yes, it does. So, I would need to know more about a situation, but, you know, it does because if the person um, doesn't feel safe where they live anymore because they're being stalked, or, maybe they were dating somebody and when they broke up, this person um, kept coming on their property or kept going to their apartment. Um, and yes, it does cover that. So if the person feels unsafe, they can use that remedy of terminating their lease early without fees or penalties to move to a place that where, the stalker or whoever doesn't know where they live.
Somebody else I've heard from families I work with, um, or that they've paid the rent and their late fees, payment rent. They paid it all in full, and then were evicted anyway, or told to vacate. And it says, is that legal? And you had said earlier that if the landlord
Yeah, I
accepted.
mean, so remember there's a difference between the housing provider telling you to move or giving you a notice from them versus an actual eviction being filed in court. So if this is an issue of, um, they didn't pay their rent, then they caught up, but the housing provider still wanted them out, the housing provider would have to go through the same process of um, giving them a notice to vacate and then following that up with a court eviction. And in this case, if their basis for the eviction is unpaid rent, but the rent has been paid, then the eviction should be dismissed if it gets to that point. But sometimes, we have these situations where housing providers will just be tired of dealing with a tenant, like say somebody who continually pays late or whatever. And they'll just give them a 3-day notice to leave, which, unfortunately that's within their rights. But, if the tenant stayed there, the only thing the housing provider could do, like I said, is file an eviction. And the basis for that would be something that doesn't exist anymore, which is, unpaid rent. So I hope that answers the question because it's kind of a difficult one. But I want to just really be clear about a notice from the housing provider is not the same as a court eviction. Not that you can ignore the notice from the housing provider, but it's doesn't do anything, right? And we get people who call us all the time and say, I'm being evicted, and we have to kind of, you know, figure out if they're saying that because they got a notice from the housing provider or they actually got served a court eviction. And then we kind of walk them through the process of the steps that would happen or should happen in the eviction process. So
Yeah. So the that original notice from the landlord is a formality. It's something that once, if they want to go to court, they have to have done that before they can
yes,
file. But
yes,
it has, the only teeth it has is that the landlord now can go to court, and because they've given the 3-day notice and they've waited till the fourth day, and now they're able to file. But even at that, when you get served about that court date, that's still not, you haven't been evicted. That means you have a court date, and hopefully, I know you said a lot of the landlords, if it has to do with rent, won't even listen to the tenants. And I mean, a lot of the courts or judges, but it's just that original 3-day notice to vacate is a formality. It's a requirement by law for them to do that before they can do anything else.
yes. And in this case, if they were given that notice because of unpaid rent or late fees and they've brought everything current, I mean, technically they can ignore that because they've met the requirement of what that was, right? They paid the rent. But they have to understand that, like Marty said, after that notice is given to them, then on the fourth day they could file the eviction in court. And the tenant just needs to know that they need to appear in court and let the judge know that they paid the rent. Because then the basis for the eviction doesn't exist. So they shouldn't have filed.
And just note, if you don't show up for court when it says to show up for court, you're going to lose. The judge is going to rule against you. Isn't that right, Francis?
Yes, and yes, and I've had folks tell me, "Oh, well, I had this or that, and I couldn't make it." Well, you know what? No one really cares, and I know it sounds harsh, but it doesn't matter. Like your excuse doesn't matter. You have a court date, and you need to appear, and there's no wiggle room there. Like you can't reschedule that. You have to go, and if you don't, just understand that you're going to get the judge is going to find automatically in the housing provider's favor or in the landlord's favor.
And that's not only uh, having you move out, but that's also all of the money they've asked for and everything. They're going to give them all of it if you're not there to state your side of the case, or have somebody go there. Does it have to be an attorney? It would probably have to be an attorney to go there um, on your behalf. Is that right, Francis?
Um, Yeah, I mean, usually the person has to appear. I don't know. I guess if an attorney is representing the person, then I guess that would be sufficient. But really there isn't a reason a judge would consider for the tenant not being there in court.
Yeah, and you say, well, I had to work that day. I had a doctor's appointment. All of that, like Francis said, it's harsh, but they don't care. They've got
Yeah,
so
they
many
just they
people.
don't, yeah.
Yeah, yeah, they're going to decide it, and that's the way it is. But now, once they've decided that, if you no show, can you appeal still, Francis?
Um, I believe you can. You just have to do it within 5 days.
Okay. Um, Monica asked if um other handicap needs such as bathroom grab bars fall into reasonable accommodations.
Yes, so those are technically, if it's a change in the structure, like grab bars, it's a reasonable modification. And the tenant has a right to request that. Um, what I think is the unfortunate thing about modifications like grab bars is that the housing provider does not have to pay for those. So essentially, they just have to approve them, and then the tenant has to pay for those to be installed. And so, sometimes you might be able to negotiate with your housing provider that, okay, if I go to Lowe's or Home Depot, wherever, and buy the grab bars, can their maintenance person install them? Because they probably already have somebody that they pay full-time on staff that, and it's not going to be an additional cost for them to assign their maintenance person to install those. But the tenant has to pay for them unless the only exception to modifications and tenants having to pay for them is if it's public housing. Then the public housing provider needs to pay for those. And they should have a fund. They're supposed to have a fund for it. And you know, I
I
don't know if
believe
it's
that,
actually a fund that exists, but they have to pay for it.
and when you say public housing, I think that's more of an umbrella. Doesn't that cover any federally subsidized housing? I mean, anything that's like
Yeah,
taxpayer
so it could
housing?
be, apartments owned by a housing authority, or it could be apartments owned by a private company, but they were built using or they get tax credits from the state or whatever, then they should pay for it. But that's the exception because there's a lot more market rate housing than there is government subsidized housing. So, in most cases, tenants would have to pay for those things on their own.
And depending on what the modification is, the landlord is has the right to require you to put it back the way it was before the modification was made when you leave the unit. Is that right,
Yeah,
Francis?
yeah, they can do that.
Yeah. Okay. What is law regarding landlord making housing apartments the unit's reasonable accommodation for individuals with disabilities? And I think we kind of just went over that. You can ask for an accommodation or a modification, but but the landlord is not liable for that unless it's government somehow government subsidized housing. Um,
Right.
the Go
So
ahead.
that's so that's modifications, which are changes in the physical structure. But there's a whole area of accommodations that are I call their exceptions to rules, policies, and procedures. So, that's a whole other area which honestly is almost more common that people ask for those types of things rather than changes to the structure. And there's a whole list of things that people could ask for. Like the example I used in the presentation, a parking space closer to your unit. It could be, you know, an exception to having to pay a pet deposit or pet rent if you have a prescribed emotional support animal. Um, and then with accommodations, there's a whole list of things that people could ask for. And the housing provider has the right then to ask for a letter from somebody that the person is under the care of or a medical provider that states the connection between the request and the disability.
Very good. Diane, I'm not quite sure I understand. I understand not providing a copy of the lease, but when you say subleases property management, and I'm not quite sure I understand the first part of that, but I understand they won't provide a copy of the lease. If you go to your landlord and ask for a copy of their lease and they refuse to provide it, what would your ramifications be, or what would you say you would do, Francis?
Yeah, that's a difficult one because if they just won't willingly give that, the only way to force them to is to take them to court, to take them to small claims court or justice of the peace court. Because you have no other way to force them unless you can get order, a judge to order them to do it.
But you should be getting that when you sign a lease. You should definitely be getting a copy of the lease. I mean, you want to have that to refer to when things come up, and you want to know how to handle it. And most of that's written
Yeah.
in the lease. Yeah.
Yeah,
Okay.
because a lot of things they won't be clarified by Texas law. They'll only be clarified by the lease. So you need to make sure that once you sign it, they give you a copy.
Yeah. And a lot of Texas law refers you back to to your written agreement, your lease. Yeah.
Yeah,
Um.
exactly.
Um.
And I just want to say too, if the person who, had the question about accommodations, if you have a specific situation that you want to talk to me about, or you just want some additional information, just send me an email.
Um. And I know there, I believe there might have been somebody on here from legal aid, or one or two people on here from legal aid this morning, but someone said that they've seen that legal aid does assist with people with facing eviction. They do that if you qualify and you qualify, but the only issue that we've heard over and over again is people wait too late to go ask for help. By the time they come and ask for help, that they've already been to court, they've already lost. They've got a writ of execution to to if you don't move out, they'll put your stuff out. Some of them, and so please look for help early. Don't wait. When you get that first 3 day notice to vacate, that's when you want to look for help if you if you're concerned about what's going to go down there. And legal aid
Yeah.
of Northwest Texas, or whatever the legal aid assistance program is for where you live, would be a good place to go. Go ahead. I'm sorry, Francis.
Yeah, and I don't want to give, people any, false hope that they'll get a legal aid attorney to represent them, because they take on very few cases where they actually go to court with the tenants and defend them. And so, but be aware that they have a lot of clinics where, you can actually go to a clinic and speak with somebody about your case. They're not going to go to court with you when the time comes, but, you can get information from them, or, ask them the best way to proceed, or, ask them if you have any defenses that you could raise. And I know they have clinics like all the time during the course of the month, some are like every, first Tuesday of the month, every second blah blah of the month. But if you look at their website, you could find a clinic that you can visit and then be able to talk to somebody one-on-one.
And and a very good other resource is us, because we do a clinic every month to give you
Exactly.
we we partner with Francis to do a clinic once a month, and for exactly that reason, for you to bring a specific issue or case to it, and at least let us try to talk through it and see if we can, might be able to help you that way too. And that's virtual, online, so you don't even have to go someplace. So, in fact, we'll give you it's in, not that it's the last slide. We'll give that to you in just a minute. Um, can the landlord refuse to accept the rent the tenant tries to pay, so that they can evict the tenants for non-payment? The the
Wait, say that
landlord,
again?
they want to know if the landlord can refuse to accept the rent that the tenant tries to pay so that they can evict them. But they can do that, but that's only after it's been late, right?
Right. Yeah, they can do that.
If if you
So
come if you're late on, go ahead, I'm sorry.
if they if they give you the 3-day notice to move, to vacate, they don't technically after that have to accept the rent. So it's unfortunate, but I'll give you an example of one way that, if we can get this Texas legislature to start considering tenants' rights. Um, in, for example, California, the 3-day notice is not just a 3-day notice to vacate. It's a 3-day notice to pay or vacate. So if within those 3 days you can pay, then the notice to vacate goes away. That isn't a choice here in Texas. In Texas, it's just a 3-day notice to vacate. You don't have the choice within those 3 days to pay the rent, and then you could stay. And that's one of the ways that, we could change the law, right? To make it better for tenants.
Yeah, and some of them some of them more or less bully people with that 3-day notice to vacate, and there should be some penalties for doing that. We see a lot of landlords abuse the 3-day notice to vacate and do everything they can to try to make you feel that's it. You just got to be out. Um,
Mhm. Now, if they do accept the rent, though, they don't have to, but if they do, then again, they shouldn't be filing eviction after that. They don't have a basis for it. So, keep your receipts. And if you end up getting served a court eviction, go and tell the judge that you don't owe them anything. You paid your rent and they accepted it.
yeah, that's your defense is that you've paid it, they've accepted it, so there's no more, there's not a no issue exists anymore. But you've got to pay the rent and the late fees. You got to pay all of it, um, um, so that when you get to court, you're not really owing them anything. Maybe you will be at the next first of the next month. Um, a real estate agents like myself can't practice law, but we have specific training regarding fair housing. Can um, we can understand and explain leases. We can advocate for you when you're looking for a rental um, and our commission is paid by the landlord. I see. Yes. There are real estate agents, the people that are licensed. If There's some apartment communities that will pay them a commission for bringing somebody to them for a lease and that kind of thing. Um, yeah, several people from legal aid are on here. I know. Um, so we said, they said this is our bread and butter. I'm sure it is right now. I'm sure lots and lots of eviction cases, but I encourage you all to bring your case to our clinic and let us talk through it. We have two types of tickets when you go to sign up for the clinic, and there will be a link to the flyer for our next clinic in the follow-up email from today's presentation, and you can go down and bring that. But you can either sign up to just observe if you just want to come and just listen to what people's cases and what advice they get. You're more than welcome to that, or you can get a presenter ticket and actually present a case on behalf of yourself or someone else. It's not legal advice. It's just trying to give you guys some suggestions of ways you might handle things or how processes work. Okay, it says, I think a lot of issues can be resolved on the front end by asking the right questions at the onset of the rental and having a professional review the lease terms. It's good to have an advocate. This is and they were thanking for the information. So yes, it is. Two things. Number one, no, when you move into a place, go through and take pictures once you sign the lease, go through and take pictures. And when you finish cleaning the place to leave, before you walk out the door, take pictures again. You got to have something to show, especially if that deposit doesn't come back and you want to defend yourself. And they said, well, we had to pay we had to pay X, Y, and Z, $500 to come in and clean the apartment. They left in a mess. And you have pictures to show. You've got to have something to show that it's not just your word against their word. Is there anything else, Francis?
No, not that I can think of. Somebody on here, a couple people, I think, we're talking about roach infestation. And, I'll tell you, we get calls like that periodically from people who are living in roach infested apartments. And, unfortunately, roaches, like Marty said, you can always call the code compliance inspectors and try to get somebody out. But in my experience, they don't really care about roaches, and it's not something that they would come out and cite a landlord for. So if the housing provider is not dealing with it and not, sending pest control or whatever, and the tenant has to do it themselves and is out of pocket for that, that is something that they can, any kind of costs that they incurred to try to remedy the problem themselves, they can try to get reimbursed by taking the landlord to justice of the peace court or small claims court to try to get their money back.
Francis, can I get you to advance the slide?
Yep.
To the first, let's do the CEU things first, and then we'll go to the last one. Okay, just to reiterate, those of you that have been on today for CEUs or wanting a certificate of attendance, we're providing CEUs for licensed social workers and licensed professional counselors in the state of Texas. If you have a different license in Texas or a license outside of Texas, you're more than welcome to go through the process, get a certificate. But please know whether they accept it or not is up to them, and we don't have any, I can't help you if they don't accept it. But you're more than welcome to the process. I've had people tell me that their jurisdiction has taken them. So please feel free to go through that process. And also, we offer certificates of attendance. Today's webinar has been worth 1.5 hours of CEU credits. You, if you're still on, you should have it. As long as you got on at the beginning, you've surpassed being on for the entire live webinar and Q&A. But you must also complete the Google evaluation survey that should pop up as you close out today. If it doesn't pop up, it'll go out in the a link to it will go out in a follow-up email that should go out either later today or tomorrow. You'll have that access to that survey. You've got to complete it before 2/8 to qualify for the certificates, and then give us till March 8th, if you would, to get those certificates out to you. Let's go to the last one, Francis, if we could.
Okay.
Please join us for our next Tenants' Rights Clinic on February 14th on Valentine's Day. Bring your love along, and we'll try to answer your questions about how to love your landlord again. I don't know. So Francis, go ahead.
And remember, there's for the clinics, there's you can sign up just to be an observer, meaning you're just listening to everything. But we really need more people to sign up that have cases or issues they want us to help them with or discuss, because I think that helps the whole group.
Yeah, absolutely. Francis, thank you. Exceptional job.
Thank you, Marty, for setting everything up.
Thanks you all, and we sure appreciate you all, and you all have a wonderful day.
Thank you.